Hi everyone, today's session is on contract law and the unit number is F6177192, and today we'll be doing learning outcome 3, which is to understand the vitiating elements that might affect the validity of a contract. So in the last sessions we looked at learning outcome 1 and 2, and we referred to the elements of a contract. And we also looked at the different types of elements, but we also referred to the rules of that govern the content of a contract. We looked at offer, acceptance, then we looked at terms and representation, and we also looked at the different terms such as express and implied terms. And we also looked at collateral contracts, entire agreement clauses. We looked at the implied terms, which would come under the terms by custom or by trade. And then we looked at the sources of contractual terms. We also referred to the Markup case 1889, the importance of that, and distinguished between conditions, warranties, and inanimate terms with reference to case law. So today we'll be looking at learning outcome 3, which is to identify just 1 minute, I'll go back to them. So identify the elements that may affect the validity of a contract. So 3.1, we're going to look at identifying the elements of actionable misrepresentation. So a misrepresentation is a form of statement made prior to the contract being formed. There are 2 types of statement that can be made before a contract forms. These will form part of the contract, not form part of the contract, therefore becoming a representation. A misrepresentation is a false statement of fact made by one party to another, which, whilst not a term of the contract, induces the other party to enter into the contract. An actionable misrepresentation must be a false statement of fact, not of opinion or future intention or law. Silence does not amount to misrepresentation. However, the representer must not misleadingly tell only part of the truth. Thus, a statement that does not present the whole truth may be a misrepresentation. Where a statement was true when it was made, but due to a change of circumstances becomes false, there's a duty to disclose the change. A misrepresentation may be fraudulently made knowingly without belief in its truth or recklessness, or negligent, which is to be made by a person who had no reasonable grounds to believe that it was true, or innocently made in wholly innocent belief that it was true. The misrepresentation have induced at least partly the party to enter into the contract and must have been relied on to at least some degree by the person to whom it was made. If that person in fact relies on his own judgments or investigations, or simply ignores the misrepresentation, then it can not give rise to an action against the person who made the misrepresentation. So now we're going to look at 3.2, which is to differentiate between fraudulent, negligent, and innocent misrepresentation. So fraudulent misrepresentation, the significance of misrepresentation being classed as fraudulent one is that the measure of the damages may be greater under certain circumstances. There are 2 remedies available for fraudulent misrepresentation: firstly, recession, and secondly, damages. Representatives should attempt a claim for fraudulent misrepresentation with caution, as the courts impose a much higher standard of proof due to the serious allegations. There may also be penalties in the event the claim is not made out. A fraudulent misrepresentation was defined in the popular case of Derry and Peake, 1889, 14 at case 337, as a false statement which is made knowingly or without belief in its truth, or recklessly careless whether it be true or false. In order to assess whether a statement has been made fraudulently, you should consider whether the statement maker knows the statement he has made is false. Secondly, that the statement maker has reasonable grounds to believe his statement is true, even if it is false. In the case of A, there will be clearly a fraudulent statement. In the case of B, the statement maker has made a false statement, but has reasonable grounds to believe his statement, it will not amount to a fraudulent statement, as it has not been made recklessly or carelessly. A statement made recklessly or carelessly needs to be a statement made which the statement maker has no belief in the truth, but does not know for sure that it is true or false. So some examples here in case law. So the first case is Thomas Witter and TBP Industries Limited, 1996. And in this case, it was clarified that where a statement is made where the statement maker has no idea whether or not it's true or false, this statement would be fraudulent due to the recklessness asserting it is true when it may not be. True statements will become false. Now, this case in regards to the statements being false is the case of With and Flanagan, 1936. And I'll just give you a little bit about the facts of the case. So in this case, the claimant purchased a medical practice from the defendant. The claimant was induced to buy the practice by the defendant's statement that the practice took £2,000 per annum. This statement was true at the time it was made. However, subsequently, defendant became ill and many patients went elsewhere. By the time the sale was completed, the practice was virtually worthless. It was held in this case that where a statement is rendered false by a change in circumstances, there's duty to disclose the change. A failure to do so will result in an actionable misrepresentation. It was suggested in this case that a misrepresentation as a result of circumstances that I've just mentioned might result in fraudulent misrepresentation or negligent one. Here are the circumstances in which this can happen. So the next one is fraudulent, where the statement maker is aware there is a duty to notify the representee of a change in circumstances, as in the case of Banks and Cox, number 2, which is an unreported case. The next one is negligent, where the statement maker is not aware there is a duty to notify the representee of a change in circumstances. Negligent misrepresentation. So negligent misstatement. A claim for negligent misrepresentation that is based in tort under common law is usually referred to as negligent misstatement. Headley, Bryan and Co. Limited and Heller and Partners Limited, 1964, looked at the and the Caparo Industries and Dickman, 1990, looked at the test for duty of care. Subsequent case law, which considered negligence of misrepresentation in the context of duty of care, concluded there would be a duty of care owed if there was an assumption of responsibility on the part of the statement maker, as in the case of Henderson and Merritt Syndicates Limited, 1995. Whether or not there's an assumption of responsibility considers determining whether the statement maker has held themselves out as possessing expertise or special skill and is aware that the other party will rely on this information. It is relevant whether or not the statement maker is an actual expert, only that they hold themselves out to be one. Then we've got negligent misrepresentation. In this case, an alternative approach to a claim for negligent misrepresentation is to pursue the claim under statute law. The Misrepresentation Act 1967, Section 2, subsection 1 allows for such a claim and contains the components. The significance of negligent misrepresentation claim under statute is that the burden of proof from the common law claim is reversed. The representor cannot escape liability simply by proving that he was not negligent. It must prove be proven that he had reasonable grounds to believe the statement, as in the case of Howard Marine and Dredging Company Limited against A. Ogden and Sons Excavations Limited 1978. Innocent misrepresentation. With the development of the Misrepresentation Act, the claim for innocent misrepresentation is extremely limited. So a claim for innocent misrepresentation will arise when a claim for negligent misrepresentation under the Misrepresentation Act has failed. The remedy for innocent misrepresentation will usually be the rescission of the contract. So 3.3 is to analyse the development of the doctrine of duress. Now, duress in contract law relates to where a person enters an agreement as a result of threats, where a party enters a contract between because of the duress, they may have the contract set aside. Originally, the common law recognised threats of unlawful physical violence. However, in more recent times, the courts have recognised economic duress as giving rise to a valid claim. Where the threat is to goods, the courts have been less willing to intervene. Although claims in restitution suggest that this position of the law may change, the basis of duress as a vitigating factor in contract law is that there's an absence of free consent. So they are getting into the contract due to duress. Duress operates at common law. Pressure not amounting to duress may give rise to an action for undue influence in equity. The effect of finding duress and undue influence is that the contract is voidable. The innocent party may rescind the contract and claim damages. The normal bars to rescission operate. Undue influence exists where a contract has been entered as a result of pressure which falls short of amounting to duress. The parties subject to the pressure may have a cause of action in equity to have the contract set aside on the grounds of undue influence. And that's like, for example, there may be a contract between a husband and wife, and the contract was only made because the husband pressured the wife into making the contract. Undue influence operates where there exists a relationship between the parties which have been exploited by one party to gain an unfair advantage, as I've just mentioned, the husband and wife scenario. Undue influence is divided into actual undue influence and presumed undue influence. Where contract is found to be entered into as a result of undue influence, this will render the contract voidable. This will enable the person influenced to have the contract set aside as against a party who subjected the other party to such influence. In addition, in some instances, the party influence may be able to have a contract set aside as against a party who's not the person inflicting the influence of the pressure. Duress to the person. Where a person enters a contract as a result of threats or physical violence, the contract may be set aside, providing there was a cause of entering the contract. There is no need to establish that they would not have entered the contract but for the threat. And this is a case that identified this was the case of Barton against Armstrong 1976. And I'll give you a little bit about the facts of the case. So in this case, Armstrong was the chairman and held the largest shareholding in Landmark Corporation Limited, a public company. Barton was the managing director and also had a substantial shareholding in there. There were two other directors, Boville and Cottrell. There had been a long history of ill will between the parties and a struggle over struggle over who should have controlling power, with Armstrong being the most aggressive. The other directors in the company were also unhappy with Armstrong and wanted him to be removed for abusing certain privileges, and they disagreed with the way he ran the company, believing him to be putting the company at risk of insolvency. However, Armstrong refused to resign. The three managed to take control of subsidiary companies and moved all credit facilities from Landmark Corporation. When Armstrong discovered the credit had been removed, he made a number of death threats to Barton to pressure him into signing an agreement which contained various elements, including the purchase by Barton of Armstrong's shares in the company at a substantial overvalue. Barton agreed to this partly due to the threats, but also due to the fact that it would mean that Armstrong would no longer have controlling interest, and he believed that he would be able to turn the company around without Armstrong's dealings. However, the company became insolvent shortly after, and Barton sought to have the contract set aside. It was held in this case that the contract could be set aside where there's duress to the person. There was no obligation to show that he would not have entered the agreement but for the threat. It's simply being sufficient that the death threats were a cause that he entered into this contract. So due to that duress, this occurred and Barton entered into the contract. Duress to goods. Duress to goods is not recognised as giving rise to grounds for having the contract set aside. In the case of Skeet and Beale 1840, the case summaries in there. We'll just click on that and see the case summary. In this case, a landlord was owed money by a tenant. He seized goods owned by the tenant and threatened to sell them immediately unless the tenant entered agreement for repayment of the sums owed. The tenant agreed to repayment terms, but then sought to have the agreement set aside. It was held that in this case that duress to goods will not suffice to render a contract voidable. And then this case of Maskell and Horner 1915, if you want to have a look at the facts of the case there as well, the case summary is there. In Maskell, it was thought that the position in relation to duress to goods is unlikely to survive if it is tested in the higher courts, particularly given the more liberal position that has taken hold in response for claims for economic duress. Economic duress. The doctrine of economic duress was first classified by Justice Keir in the Sibian and Sabota case. Whilst the contract was not held to be voidable for duress, Justice Keir did not state that where there exists coercion of the will so as to initiate the consent, it should be possible to set the contract aside. However, commercial pressure was not enough. In the case of Occidental Worldwide Investment Corporation and Skibbs, the Sibian and Sabotian 1976, following Justice Keir's line of reasoning, economic duress was found to exist in the Atlantic Baron. However, the claimant lost their right to rescind. The North Shipping case, you could go on there and get the facts of the case in regards to the case summary, and the Poe on Law Long 1975, the case summary is there. You could do this for extra reading, additional reading for your homework for next week. Okay, so the Privy Council identified 4 factors to consider in assessing whether economic duress was present. First one, did the person claiming to be coerced protest? Secondly, did the person have any other available course of action? Thirdly, were they independently advised? Fourthly, after entering the contract, did they take steps to avoid it? The requirement for vitiation of consent was replaced in the Universal Sentinel with the absence of choice, as in the case of Universal Sentinel 1983, where Lord Scarman stated that the classic case of duress is, however, not the lack of will to submit, but the victim's intentional submission arising from the realization that there is no practical choice open to him. Accordingly, 2 elements of duress were identified: compulsion of the will, of absence of choice, and illegitimacy of pressure. So illegitimacy of pressure. Initially, it was thought that the threat must be unlawful, and the case for this was the dim skill skipping and International Transport Workers Federation, and the case summary is there. So in this case, just a little bit about it is the ITWF threatened strike action unless certain demands were met. The cost of the strike would be astronomical for dim skill, and therefore they agreed to the demands. They later sought to have the agreement set aside as being procured by duress. There was clearly present a coercion of will and absence of choice. The main question for the court was the legitimacy of the pressure. At the time of the threatened strike, the EVA look was in Sweden. The court had to determine whether English law applied or Swedish law applied to the threatened action, as under Swedish law, the threatened strike would be lawful, so there would be no illegitimate pressure applied. However, under English law, the strike would be unlawful and the threat would be regarded as illegitimate. And it was held that English law applied and the threat was therefore unlawful and illegitimate in the dim skill case. Some cases you can look at for next week for your homework is the CTN, Cash and Carry and Gallagher, and the case summaries are all there. So look at in your own time, please. It will help you towards doing your assignment. However, dicta from Lord Hoffman in Privy Council case of R and Attorney General for England and Wales, 2003 UK PC 22 suggests a different approach. He suggested that the legitimacy of the pressure must be examined from two aspects. First, the nature of the pressure, and secondly, the nature of the demand which the pressure is applied to support. Lord Scarman in the Universal Tankships case, generally speaking, the threat of any form of unlawful action would be regarded as illegitimate. On the other hand, that the fact the threat is lawful does not necessarily make the pressure legitimate. As Lord Atkin said in Thorn and Motor Trade Association 1937, the ordinary blackmailer normally threatens to do what he has a perfect right to do, namely communicate some compromising conduct to a person whose knowledge is likely to affect the person threatened. What he has to justify is not the threat, but the demand of money. The effect of finding of duress. And since duress operates to deflect the will of the party rather than vitiate the consent, the effect of finding duress is always to make a contract voidable, not void, as in the case of IFA Limited and Federal Trade SPA 2001. 3M1. So this is for the extension activities that you need to do when you're doing your assignment. So if you want to do the extension activities, you need to examine the remedies available for fraudulent, negligent, and innocent representation. So the remedies for misrepresentation is rescission. So this is when a contract has been induced by misrepresentation of any kind. The contract does still confer obligations upon the party, but the contract will be voidable. Voiding the contract at this stage is using the remedy of rescission. There are a number of restrictions to use of this remedy. These are known as bars to rescission. Affirmation. Affirmation refers to an affirmation of the contract whereby, despite the misrepresentation, the representee had held themselves out to be happy with the contract as it is, therefore affirming the misrepresentation, as in the case of Long and Loyal 1958 to ALLER 402. In the event of misrepresentation, it is expected that the representee, if they are not happy with the contract, will take action to remedy the contract. Lapse of time. There's differing approach by the courts for different types of misrepresentation. In the case of fraudulent misrepresentation, the lapse of time will begin at the time the fraud was either discovered or could have been discovered. As for misrepresentation, which is negligent or innocent, the lapse of time will begin from the date of the contract, as in the case of Leaf and International Galleries 1952 KB 86. And the facts of this case, I'm just briefly going to go through that. The claimant in this case purchased the painting from the defendant. Both parties believed that the painting was by the artist Constable. In fact, 5 years later, the claimant discovered that the painting was not a Constable painting. The claimant brought an action based on misrepresentation and mistake. The claim based on misrepresentation was successful. However, since it was innocent misrepresentation, the claimant had lost the right to rescind the contract through lapse of time. With innocent misrepresentation, the time starts to run from the date of the contract, not the date of the discovery. The claim based on the mistake was unsuccessful, as the mistake related to the quality and did not render the subject matter something essentially different from that which it believed to be. He believed he was buying a painting and he got a painting. Restitution in integrum. The barter rescission refers to where a rescission of the contract is no longer possible. This is the case where the goods under the contract have been used, consumed, or have been perished, as in the case of Clark and Dixon, 1858. In the event that the goods have only been partially consumed, rescission is more complicated, as in the case of TSB Bank PLC against Camfield, 1995, and in the case of D. Molestein against Ponton, 2002, 1ALLER 587. This approach that was used in TSB was rejected, and it was argued a partial rescission may be possible where you can split the contract into multiple parts. Third-party interests. Where rescission would encroach on the rights of a third party, the remedy would be unavailable, as in the case of Crystal Palace Football Club 2000 Limited and Dowie 2007. Damages. The measure of damages differ for each of the types of misrepresentation. Therefore, each will be considered in turn. So, fraudulent misrepresentation. This requires a high standard of proof, as in the case of Doyle and Albee Ironmongers Limited 1969, is an authority to effect that damages are awarded on the tortious basis, aiming to put the aggrieved party in the position they would have been if the misrepresentation was true. This standard is usually subject to a test of reasonable foreseeability, where a loss will only be claimable if the statement maker could have reasonably foreseen that the fraudulent statement would have resulted in such a loss. Negligent misrepresentation under common law. Negligent misrepresentation claimed under Hedley, Bryan and Heller and the tort of deceit are extremely limited in comparison to those for fraudulent misrepresentation. Unlike damages for fraudulent misrepresentation under tort of deceit, the damages are limited by the test of remoteness. The test of remoteness from Overseas Tank Ship Limited against Mort's Dock and Engineering Company, the Wagon Mould case, only allows damages to be claimed that are reasonably foreseeable. If the claimant has been negligent to some extent, damages may be reduced by the way of contributory negligence, apportioning some of the blame to the claimant. Negligent misrepresentation under the Misrepresentation Act. Under Section 2, subsection 1 of the Misrepresentation Act, damages are awarded on exactly the same basis as fraudulent misrepresentation. Therefore, the statement maker will be liable in damages for all consequential losses as a result of the statement, irrespective of their foreseeability, as in the case of Shaney Ford Supplies Limited and Edge 1987. Section 2, subsection 2 of the Misrepresentation Act clarifies that the relationship between rescission and damages. The courts have identified that rescission can often result in unfair consequences, and therefore damages may be awarded as an alternative to rescission. This means that there cannot be a claim for rescission and damages. It must either be one or the other. 3M2. Contrast the effects of misrepresentation and mistake on a contract. If the statement amounts to a term of rescission is a remedy available when the underlying basis for making a contract is fundamentally tainted. Some conduct on behalf of the contracting party undermines the very reason that the other party made the contract in the first place. The contract may be in as if the contract never ever had been made. That's the status quo ante. It's treated as non-existence. The transaction established by the contract is brought to an end with respective effect. When the right to rescind is available and properly exercised, it is said that the contract has the slides just came off. So the transaction established by the contract is brought to an end with retrospective effect. When the right to rescind is available and properly exercised, it is said that the contract has been rescinded. These cases where rescission was available even when contracts had fully been performed. So rescission. This sets aside the contract and primarily aims to put the parties back in their original position as if the contract had never been made. Rescission can be sought for all cases of misrepresentation. However, this is a discretionary remedy, meaning that the courts will not always allow a party to rescind, and the injured party may lose the right to rescind if A, he has already affirmed the contract, B, he has not acted to rescind the contract in a reasonable time, C, it is or becomes impossible to return the parties back to their original position, or D, a third party has acquired legal rights as a result of the original contract. Indemnity. This is the court may order payment for expenses necessarily incurred in complying with the terms of the contract. Damages. This remedy varies according to the type of misrepresentation. In fraudulent misrepresentation cases, there's an automatic right to damages. In negligent cases, the injured party may claim damages under common law or under Misrepresentation Act 1967, Section 2, subsection 1. In situations of innocent misrepresentation, the court has discretion whether to award damages and may opt to award damages in lieu of rescission. Mistake. The effect of mistake on the validity of a contract depends on the type and nature of the mistake made. The general rule is that where a mistake has been made by the parties at common law, the contract may be deemed void as if the contract had never existed. Equity takes a more flexible approach in that contracts containing certain mistakes may be treated as voidable where either party can terminate the contract. However, a fundamental mistake, often referred to as as an operative mistake may be rendered a contract void. There are 4 types of mistake: common mistake, mutual mistakes, unilateral mistakes, and mistake as to the identity. So common mistakes, where a common mistake occurs, the parties appear to be in an agreement but have entered into the contract under the same misapprehension. Where such a mistake is fundamental to contract, it may be void ab initio, which is void from the very beginning. In the case of Bell and Lever Brothers, 1932, it was held that for a common mistake to be operative, the mistake must go to the root of the contract. Firstly, by looking at the mistake as to the existence of the subject matter. Secondly, mistake as to the title. Thirdly, mistake as to the quality. Fourthly, mistake as to the possibility of performing the contract. And fifthly, mistake to inequity. And there are details or additional information and handouts on Moodle for you to have a look in regards to the issue of common mistakes. Mutual mistake is where mutual mistake occurs. There's misunderstanding between the parties as to each other's intentions, and they are said to be at cross purposes. A mutual mistake negates consent, and therefore no agreement is said to have been performed at all. Then you've got unilateral mistakes. Unilateral mistake is where only one party is mistaken and the other party knows about it and takes advantage of an error. A unilateral mistake also negates consent and the existence of an agreement. Number 1, unilateral mistake as to the terms of the contract. And number 2, unilateral mistake in equity. Mistake as to the identity. So where mistake as to identity of the other party to the contract is made, the contract will be deemed void if the identity of that person is central to the contract. However, where the parties negotiate in person, there's a presumption that there's an intention to do business with the person in their presence, in which case it is unlikely that contract will be void, as it is demonstrated by a case of Phillips and Brooks, 1919. A rogue purchased some items from the claimant's jewellery shop, claiming to be Sir George Bullock. He paid by cheque and persuaded the jewellers to allow him to take the ring. He gave the address of Sir George Bullock, and the jewellers checked the name, matched the address in the directory, and the rogue then pawned the ring at the defendant pawnbrokers in the name of Mr. Firth and received £350. He then disappeared without a trace. The claimant brought an action based on unilateral mistake as to the identity. It was held in this case that the contract was not void by mistake. Where the parties transact face to face, the law presumes they intend to deal with the person in front of them, not the person they claim to be. The jewellers were unable to demonstrate that they would only have sold the ring to Sir George Bullock. These are some of the references: e-law resources for your case law on duress, juster.org, and OpenEDU EU, and Halliwell's on recession of a contract meaning. Now you need to go onto Moodle in regards to extra resources, and in regards to the case summaries on each case, have a read of them. They're all on e-law resources, and you'll be able to understand the full facts and what was the decision in the case. So please go on to the law resources page, but also go on to Moodle for your additional resources and any sort of additional ebooks or anything like that. And we're going to finish off this session now. This was Learning Outcome 3, and the next session will be Learning Outcome 4. Thank you for attending today's session.